In a significant recent development, the Honorable Supreme Court in Deen Dayal Tiwari versus State of Uttar Pradesh 2025 Supreme Court 3 judges bench observed that the capital punishment is an exception. Even in cases of multiple murders, it is avoid to death sentence if there is possibility of reform. Recently, the Honorable Supreme Court upheld the conviction of a man for murdering his wife and four minor daughters, but commuted his death sentence to life imprisonment without remission, citing a lack of criminal antecedent. Prison reports indicating reform potential and precedents against the death penalty in multiple murder cases. The court added that even in cases involving multiple murders, no death sentence could be imposed if the convicts display a reform potential supported by other mitigating factors such as age, lack of criminal antecedents, income, etc. The Honorable Court has also observed that this court has consistently recognized that the imposition of capital punishment is an exception and not the rule. Even where multiple murders have been committed, if there is evidence or at least a reasonable possibility of reform, a lesser sentence must be preferred. A bench comprises of Justice Vikram Nath, Sanjay Karol, and Sandeep Mehta heard the case in which the appellant was convicted of murdering his wife and four minor daughters based on circumstantial evidence and was sentenced to death, a verdict later upheld by the High Court. The court also observed that the case does not fall within the rarest of rare doctrine propounded in the case of Bachchan Singh versus State of Punjab 1980. As stated in Bachchan Singh's case, the death sentence is to be imposed only in exceptionally grave circumstances such as when the crime is extremely brutal, grotesque, diabolical, revolting, shocking the collective conscience of society. They also held that the crime demonstrate extreme depravity and inhumanity, such as mass murders, heinous sexual offences followed by murders and killings of law enforcement officers. There is no possibility of convict being reformed and sentencing them to life imprisonment would be inadequate in serving justice. The court has observed that before determining whether a case falls under the rarest of rare category, the court emphasized the need to consider factors such as motive, manner of execution, severity of the crime, and the convict's potential for rehabilitation. If reform is possible, the court held that life imprisonment should be imposed instead of the death penalty. Thank you.